Unless you've been living under a rock, I'm sure you've heard about the new home inspection law that was passed and due to take effect Wednesday, October 15th. But in case you're not aware of it, I want to make this as simple as possible. So before you write off inspections forever and start waving your arms, let me walk you through what this really means. Welcome to Let's Get Frank About Real Estate. I'm Frank McManus with Coldwell Banker. And think of this like new traffic rules for buying homes. Buyers, you don't have to take the inspection route, but you get the right to, as there is no more wave-in inspections to make your offer more competitive. And sellers, don't try any sneaky maneuvers on the contrary, because the state is watching. First off, buyers will now explicitly have the right to obtain a home inspection should they want to. But here's the kicker. Once you're under agreement, you can choose to not have an inspection. This means inspection waivers are still possible, but not until after your offer is accepted, i.e., you can't be strong-armed into waiving due to the competition in the house of interest. Second, sellers and their agents will now be legally obligated to hand over a new disclosure form to both buyers and sellers, either before or at the time of the submission of the offer. And this form spells out everyone's rights and obligations under this new law. Bottom line, buyers, you no longer have to wave the white flag and feel pressured into waiving the inspection to get your offer accepted. Now, sellers, listen up, because this new law is for you and affects you as well. You can't demand only offers that waive or limit the inspection. You can't accept an offer contingent on limiting or skipping the inspection, and you can't counter an offer asking the buyer to waive the inspection. Translation, you can't pressure someone into skipping the inspection to make your life easier. That is now off the menu. And this applies to for sale by owners as well as those sellers using an agent. You must provide the new Massachusetts mandatory residential home inspection disclosure to the buyer, and it has to be signed before or with an offer, no exceptions. And failure to follow this can be used as evidence of misrepresentation or unfair business practices, which will be treated as serious business, and the penalties will reflect that. Now, you're probably wondering, there must be some wiggle room somewhere, right? And you would be correct, but only a little. You cannot include terms that would render the inspection meaningless. For example, giving a buyer 12 hours to schedule, execute, and review an inspection report. That would be deemed as too tight of a time frame, and the law doesn't allow it. So, what is negotiable? Well, you may negotiate a reasonable dollar threshold, i.e., if the repair estimates exceed a certain amount, the buyer has the right to cancel the offer or walk away. You may negotiate a reasonable deposit refund limit, meaning that if a buyer walks, you can withhold some portion of the deposit. But, and this is a big but, reasonable is not defined in concrete numbers. What's reasonable in Greater Boston may look different out in the Berkshires. It depends on the property, the market, and the location of the deal. However, there are some exceptions. The law does not apply to public auctions, foreclosures, family transfers, divorce settlements, estate planning transactions, or new construction under conditions or certain conditions like receiving a home warranty. Now, what are the penalties if this law isn't followed, as I kind of alluded to earlier? Thank you so much for asking. Sellers could be viewed as misrepresenting the property. Agents, you're flirting with the violation of the Chapter 93A laws, and neither of these would be settled in small claims court, if you catch my drift there. So here's the takeaway. The new law is meant to level the playing field. It forces transparency, puts pressure on sellers to now follow the rules, and gives buyers a little bit of breathing room. But it also limits how much you can maneuver in contract terms. So it's seemingly some kind of clever balancing act, or at least they're trying to make it as such. Now, if you're buying or selling a home after October 15th, you must understand your rights and obligations. You must talk strategy with a realtor who knows these rules inside and out. and you must make sure disclosures and forms are handled correctly. So in conclusion, I say this with a little bit of humor, but a lot of seriousness. Don't let ignorance cost you a whole bunch of money in legal fees. If you have any questions or thoughts, drop them in the comments or email me directly at frank.mcmanus@cbrealty.com. As always, I hope this helps you. And for more than 380 additional videos like this with tips on all things real estate, please like, follow, share, and subscribe to any of my social media pages. Thank you so very much for watching, and until next time.